My comm law paper, I focused on public employee protection under the First Amendment, and the case that I chose for that was, or that I chose to analyze, was Heffernan versus City of Paterson, which Paterson's a city in New Jersey. So Heffernan was a police officer in Paterson in 2005, and his police chief had been elected by the mayor, or the current mayor, and that mayor was running against Lawrence Spagnola, and Heffernan was seen by other police officers picking up a Spagnola campaign sign, like a lawn sign, and obviously that's a direct competitor of the current mayor. So the next day at work he was demoted, and he sued under the idea that because he was demoted doing a protected action, that's not a reason for demotion. And also, obviously, political speech is very protected, and public employees usually receive protection for their political speech. So when he made it to district court, they actually ruled that he didn't get First Amendment protection, because if he had been picking the sign up for himself, then it would have been expressive action. But because he was picking the sign up for his mom, technically it wasn't expressive action on his part. So district court ruled that he would not receive First Amendment protection. So I analyzed some cases that were related to public employee protection, what the laws were and why they were in place. And the first case that I came to is Pickering v. Board of Education. This case happened in 1968, and basically what happened was Pickering was a school teacher, and the school that he worked for was asking for more taxes under the impression that those taxes would be spent on or for educational purposes, for classroom materials, for things like that. But apparently the Board of Education was saying that's what they were doing, but really they were prioritizing athletics over academics. So Pickering wrote a letter to a newspaper editor complaining that wasn't okay, and complaining that they were basically lying to the taxpayers. And the Board of Education sued under the guy, fired him, and then he sued the Board of Education, saying that it was a protected First Amendment right to be able to write that letter. And sort of what the precedent that this case set was that there's a balance that needs to be set between keeping an organized workplace and public employee First Amendment protection. And so basically what they decided in this case was that a public employee can speak out against their employer and the place they work for if it's related to public concern. So in this case, a school obviously is related to public concern, as those are taxpayers and they're paying for their children. Well, not paying for their children to go there, but paying the money to support that school where their children go. So that's obviously a public issue, and he was trying to bring light on a public issue. So where the Board of Education argued that he was causing a disruption to the school, because that sort of balance of disruption versus bringing concern to a public issue, he won the case based on that. So this case established that if an employee does complain or does bring light to an issue in their workplace, as long as it isn't completely disruptive to the workplace and is a public concern, then they are protected. So the second case I went to was Connick versus Myers. So what happened in this case was Myers was working as an attorney's assistant, and they told her she was going to be transferred to a different section. She didn't want to be transferred. She expressed that she didn't want to be transferred, but they still decided that her transfer is going to go through. And then, being unhappy with that and having complained to her superiors, the next day after she kind of found out that her transfer was confirmed, she created a questionnaire that she gave out to all the employees that were sort of below her supervisor line, and basically asked how they felt office morale was, and asking about the supervisors, and just sort of questioning her supervisor's decision-making ability. And so this case narrowed the scope for public employee protection, and basically it made the test harder to pass. It made it so that the Pickering test became the Pickering-Connick test, and it made it so that that public concern element for the employees was much, much more important. So they ruled that her questionnaire isn't of public concern, although it was a 5-4 decision, and some of the Supreme Justices said that she was complaining about the efficiency of her workplace, and it's a government workplace, so therefore it is a public concern. But in general, they made it more difficult for a public employee to win a free speech case due to needing to prove that what they're the issue they're bringing light to, or their situation, is of public concern, as well as not causing a massive disruption to the workplace. And so the third case that I analyzed was Garcetti versus Ceballos, which happened in 2006, which was basically Ceballos was a detective in the police force in Pomona, Los Angeles, and he read an affidavit, which is basically the writing portion to a warrant, and it had misinformation in it. It had information that wasn't true, which that information allowed the police to get a search warrant, and the lawyer that provided Ceballos with the affidavit said that without that false information, they probably wouldn't have been able to get that search warrant. So Ceballos checked out the falsities, and he agreed that they were wrong, and then he went to his supervisors and provided them with that information, and they had a meeting with the sheriff's office that had originally provided that information, and none of that went well. And then after that, when they decided to continue forward with the case, even with Ceballos' concerns, Ceballos noticed that he was demoted and transferred, and basically was punished for for analyzing this search warrant. And this case is really important because it narrowed the scope of public employee protection even further, and it made it that anything that's pursuant to one's job is not covered. So anything that you say, anything that you do that's required for your job is not covered under First Amendment protection. And where this starts to get like really, really sketchy and really, really hard to split the hairs of, and where it would be case by case, is in any classroom situation. So think of a teacher. Anything that they talk about in their classroom would be considered related to their profession, and therefore wouldn't be covered under the First Amendment. So this case just made it really, really difficult to decipher whether or not a public employee's speech should be protected, because it's hard to sort of tell what is necessarily part of their job and what isn't sometimes. And it just really narrowed the scope. And most people that have analyzed this case, and most of the articles that I read, were very critical of this case, saying basically that for his position, for Ceballos' position, maybe that's possible, but there's lots of public employees that wouldn't really work, or that'd be really difficult. And the most common example is for teachers. So back to Heffernan v. City of Patterson. So after he lost in district court, he appealed, and the case went to the Supreme Court, where it was overturned, and they sided with him. So in terms of his actions and what he did, getting a campaign sign and how that's protected political speech, he would 100%, he should be protected, because it happened out of the office. It caused no disruption to the workplace, and elections and picking political figures is public concern. I mean, those are public figures, they're public officials, so that is a public concern. It didn't cause the disruption in the workplace. And where this case gets really interesting, and where it is a precedent case where there really hasn't been one, is in the fact that he wasn't actually expressing an opinion, and it wasn't really expressive action. It wasn't really him exercising his First Amendment protection. But the Supreme Court ruled that if there's a misconception, if there's a mistake, and you are punished for it, you're punished for doing something you're punished for a perceived action that is protected by the First Amendment, then you are protected by the First Amendment. So it's really interesting that this precedent case sort of extended that First Amendment protection a little bit further. And although I still think kind of every public employee First Amendment case is case by case, and each one there's very sort of thin hairs of deciding the outcome of the case, it's good for this case at least that the scope wasn't narrowed even further, and that the First Amendment did protect Heffernan. Thank you.